I think we'll start in just about a minute or so.
Jeffrey Star?
Yeah,
Oh, he's
so pretty interesting.
yeah, wrote a wonderful book.
Okay. Thanks, everybody, for coming today. Looks like we got a really good turnout. I guess anything but pizza is appreciated. This is a panel on the law as it relates to the news media specifically. It's sponsored by the Duke Sports and Entertainment Law Society and the Duke Bar Association. Thanks to them. We feel it's a pretty timely and important panel, considering that from the White House to the local courthouse, many journalists are struggling to do their jobs while ducking secrecy and subpoenas. Many attorneys and journalists are complaining about a recent chilling effect on the free press. New York Times editor Bill Keller called the growing limitations on the press a serious and continuing threat and an alarming assault on our ability to explain how the government and other powerful institutions work. Other issues like libel, access to public records, and prior restraints are of daily concern to journalists and the lawyers who represent them. Today we have a distinguished panel of guests to address some of these issues and should have time for some questions at the end. So let me introduce the panel. On the far end is John Bussian, who is one of the leading media and First Amendment lawyers in North Carolina. His firm represents the Freedom Communications Papers, including 9 North Carolina newspapers and many more in other states. He represents member newspapers of the North Carolina Press Association and the Southern Newspaper Publishers Association, the News and Observer, the Durham Herald-Sun, WNCT-TV in Greenville, and the Duke Student Publishing Company. And he's litigated for the Associated Press and the Houston Chronicle. John is a graduate of Duke University and Georgetown Law. Professor Chemerinsky probably needs a little introduction to most of you. But in addition to his teaching and scholarship on constitutional law and federal courts, he's been a frequent contributor to the Los Angeles Times, various North Carolina newspapers, and other publications, and has been a commentator and consultant for CBS, CNN, Court TV, and other electronic outlets. He has covered issues ranging from O.J. Simpson to the recent Supreme Court nominations. In addition, he's argued many cases involving issues of particular concern to the news media. In 2003, the Society of Professional Journalists presented him with its Freedom of Information Award in recognition of his efforts. Henry Weinstein is the legal affairs writer at the Los Angeles Times. He has covered literally hundreds of high-profile court cases, including the O.J. Simpson trial and the trial of the police officers who beat Rodney King. He's won numerous local and national reporting awards, and in 2002 was named Alumnus of the Year by the Daily Californian, the student newspaper at Berkeley. Last fall, he won the John Chancellor Award for Excellence, presented by the Columbia University Graduate School of Journalism. He has lectured and taught at Berkeley, UCLA, USC, and South Carolina. Is there anywhere I missed? No, okay.
Okay.
To his left is Tom Leatherbury. Tom is a partner at Vinson Elkins in Dallas and is one of the top media and communications lawyers in Texas. Among his many achievements was successfully defending 60 Minutes and the late Ed Bradley in a libel case in El Paso. He has represented the New York Times, the Dallas Morning News, and many other media outlets in the courtroom. He teaches communication law to aspiring journalists at Southern Methodist University and is the past president of the Freedom of Information Foundation of Texas. So let me ask Professor Chemerinsky, would you start us off?
Sure. It's really an honor and a pleasure to be part of this distinguished panel. I want to thank them for coming, and I also want to thank all of you for coming on a beautiful Friday afternoon. My understanding is that more than anything else, we're going to focus on 2 issues today. One is issues with regard to the ability of reporters to keep their sources confidential, and the other is the ability of the government to punish the press for publishing classified or secret information. And what I was asked to do was to give a short summary of the law in each area to then facilitate more in-depth discussion by the panelists. In terms of reporters' privilege, often reporters rely on confidential sources. Probably the most famous instance of this was when Woodward and Bernstein relied on Deep Throat for getting key information to expose the Watergate cover-up. The question is whether or not reporters have any privilege they can assert in court so they don't have to disclose the identity of their sources, such when they're subpoenaed before a grand jury. The key case here was Brandsburg versus Hayes in 1973. It actually was several cases that were consolidated together before the Supreme Court, all posing the same issue. If a reporter is subpoenaed before a grand jury, can the reporter claim a privilege under the First Amendment so that he or she doesn't have to disclose the identity of the source? The Supreme Court, in a 5-4 decision, ruled against the reporters and against the existence of reporter privilege. Justice Byron White wrote the opinion for the court. He said that in general, the law refuses to give the press any greater rights than other citizens have, even the press involved in the gathering of information. He said the law has the right to every person's evidence. He said if the First Amendment gave reporters some protection, then it would be necessary to define who is the press. And the court doesn't want to go down that path. The court said the interests in law enforcement outweigh the First Amendment interests that are involved. Justice Lewis Powell wrote a concurring opinion. In it, he articulated a balancing test. He said there's a need to balance the law enforcement needs for information against the press needs for secrecy. Immediately following Brandsburg, there were proposals introduced into Congress to create a federal shield law, a statute that would give reporters the ability to protect the confidentiality of their sources with certain limited exceptions. A majority of states across the country do have such shield laws. They vary in scope, but generally they give reporters the ability to keep sources confidential with limited exceptions. The federal proposals for shield law have never been able to get through Congress. To this day, there's no federal shield law. In the now 34 years since Brandsburg, lower courts have divided as to how to apply it. Some lower courts have focused on Justice Powell's concurring opinion. They said, well, he was the fifth vote for the majority in a 5-4 decision, so his opinion should find the scope of the majority. He used a balancing test, so that should be the approach. And I can point you to a number of Court of Appeals decisions that have used the balancing approach. But there are many other circuits that have said, Justice Powell concurred in Justice White's majority opinion. Since it was the majority opinion and it rejected any privilege with regard to grand jury subpoenas, none exists. Justice Powell's concurring opinion deserves no weight. This most recently came to a federal court of appeals in a case called In Re Grand Jury Subpoena, Judith Miller, when a reporter for the New York Times, Judith Miller, was subpoenaed before a grand jury and asked to release her sources with regard to revealing that Valerie Plame Wilson was a secret operative of the CIA. She refused to do so. She went to jail, I think 84 days, was
85.
it? 85 days. And her lawyers took the case to the D.C. Circuit. There was a companion case at the same time on behalf of another reporter. The district court rejected her claim of reporter's privilege, and the D.C. Circuit flat out rejected that there was any ability of reporters to keep their sources confidential, relying on Brandsburg versus Hayes. Cert was sought in the Supreme Court. My own prediction was I thought this was a case the court was going to take. There's a split among the circuit's approach. It's a high-profile case. But then in June of 2005, the Supreme Court denied cert, and Judith Miller stayed in jail until she said her sources gave her permission to release the information that was sought. So that's where we are right now. Brandsburg is still the case, still some division in Court of Appeals opinions. There's no federal shield law. There are state shield laws. The other issue we were going to talk about, which is quite different, is when can the press be punished for reporting classified information? You might remember in 1971, in New York Times versus United States, the Pentagon Papers case, the federal government went to federal court to get an injunction to stop the New York Times from publishing the Pentagon Papers, a secret classified history of the Vietnam War. The Supreme Court, in a per curiam opinion and in a 6-3 decision, ruled in favor of the New York Times and against the United States. The per curiam opinion said, the government failed to meet the heavy burden necessary to justify a prior restraint, an injunction against publication. But at least two of the justices, Justices White and Douglas, in their separate opinions said, but maybe the press can be punished once they publish the information for violating federal statutes that prohibit the publication of classified information. And this issue has remained open all of the years since New York Times versus the United States. In fact, you might remember in December of 2005, the New York Times reported that there was a secret program of National Security Agency eavesdropping on phone and electronic communications, and the Attorney General went on Meet the Press and suggested that they were considering criminal prosecution. The Washington Post reporters won a Pulitzer Prize for reporting that the CIA had secret rendition camps, and some called for the Washington Post to be punished for publishing this secret information. The reality is there's some old, very broadly written federal statutes that could be used against the press for doing this. Since the statutes have not yet been used against the press, it's unclear what they mean. And here I just want to quickly tell you what the statutes are to set up the discussion. One of the statutes is 18 United States Code, Section 793. It was adopted as part of the Espionage Act of 1917. For those of you who have taken or are taking First Amendment law, you know that other provisions of that statute were key in what became some of the first First Amendment cases decided by the Supreme Court, like Schenck versus United States, Debs versus United States, Frowick versus United States. Well, there are still many provisions of the Espionage Act that remain. Section C of that law prohibits receipt of secret national defense information with knowledge that the source had obtained it in violation of the Espionage Act. One of the broadest and most troubling provisions is Section E. It prohibits a person in unauthorized possession of national security information from willfully communicating it if, and I'm going to read you the language, if the person believes that the information could be used to injure the United States or to advantage a foreign country. Also, it says that if somebody has such secret national defense information, they are required to turn it back to the government. If they continue to possess it, that in itself is a violation. And Section G prohibits a conspiracy to violate this law. This is a statute that's never been used against the press. But you easily see how it could be. If the press publishes national defense information, that's a broad definition of the statute, they're then violating Section E of the statute. They're engaged in a conspiracy. There is a case pending that has implications for the press. It's a case called United States versus Rosen. It's pending now in the Eastern District of Virginia. It involves a couple of lobbyists for the American Israel Public Affairs Committee who obtained information from government officials and then turned it over to the press. And this was information that was said to fit within the scope of this statute. And they're being prosecuted for violating this statute. Last August, the federal district court denied their motion to dismiss on First Amendment grounds. Now, a key issue in this case, and that will come up in any other cases under the statute, is what's the scienter requirement here? What's the mental state that's required for prosecution? Is it a strict liability offense? The other extreme, does it have to be proof that the individual acted with the intent of wanting to harm the United States? And that's going to be the key issue with regard to the Rosen litigation. It would be the key issue if ever the government tried to use this, say, against the New York Times or the Washington Post for the revelations I mentioned. Another important statute is 18 United States Code, Section 798. It was adopted in 1950. And what it specifically does is makes it a crime to publish classified information, quote, that concerns communication intelligence activities. Now, much of this statute is about prohibiting publishing secret codes, but it also prohibits publishing communication intelligence activities. And some commentators in op-ed pieces and on blogs have said that the New York Times violated this statute when they revealed the secret NSA spying because they were revealing secret communication activities. This is a statute that has never had a prosecution under it in such a circumstance, so hard to know again what's the Siena requirement, how might it be applied. One other statute that has been applied against the press is 18 United States Code section 641. This makes it a federal crime to knowingly use materials stolen from the federal government. In a case involving a man by the name of Samuel Morrison, he obtained information about a Soviet destroyer. It was obtained illegally from the federal government, and he turned it over to a British publication. And he got convicted under this statute. There's a Fourth Circuit opinion that says that the First Amendment doesn't provide automatic protection. And it doesn't matter that Morrison wasn't financially profiting from it. The Fourth Circuit says, though not unmindful of First Amendment concerns, if somebody has material stolen from the federal government and it's used, that's enough. There's other specific federal statutes. The Intelligence Identities Protection Act, for instance, makes it a federal crime to disclose the identity of a secret operative. But these are the main statutes that might be used against the press in the kind of circumstances I was describing.
Okay. Hi, thanks for having me. It's great to be here with these two terrific lawyers and one of America's greatest law professors with whom I had the privilege of teaching a class at USC a few years ago. I'd like to talk briefly about the importance to reporters and the public of both confidential sources and of reporters keeping confidential some aspects of how they do their work. And I'll acknowledge that both of these are thorny issues, and I will just add as one caveat is that even though I was part of a group of people at my newspaper that was involved in revising our ethics code to deal with some of these issues, I today speak only for myself. I don't speak for the newspaper. Virtually every good journalist that I know has used confidential sources either for background information in order to obtain leaked documents at one time or another, be it in a story about local government corruption, dangerous practices in a hospital or a factory, death squads killing dissenters in a Central American country, or sexual harassment in a law firm, which my wife wrote about extensively. The examples are endless. There would have been no revelation of Watergate, as Erwin mentioned, the Iran-Contra arms for hostage deal, or the CIA's secret prisons, unless reporters had been able to assure sources that they would protect their identities, perhaps on pain of the reporter going to jail. And I'm not being overly dramatic about this when I say some sources would clearly either lose their jobs or be subject to other severe forms of reprisals if their identities were revealed. Most reporters I know take these matters really seriously. I can just on a personal note, in 1974, when I was a very young reporter, I was confronted with the prospect of going to jail for 18 months after I interviewed a federal fugitive in Canada. I can tell you it was a daunting and frightening prospect. Fortunately, I had a very good lawyer who persuaded a federal prosecutor not to put me into the dock. And 10 years after I wrote that story, the subject of the story returned to the United States and was acquitted of all the charges against him. During his trial, he disclosed for the first time where our interviews had taken place, in public parks and open places in Toronto, Canada, which he had designed because in the goal of helping to prevent me from being charged with harboring a federal fugitive. It was a particularly considerate act on his part, I must say. That, of course, is a strikingly different situation than the most common impression that people have of the way journalists meet with confidential sources, perhaps best emblazoned on people's memory in Alan Pakula's wonderful movie, All the President's Men, about Watergate, where you saw the very dashing Robert Redford playing Woodward meeting in a garage in the middle of the night, and there was this shadowy voice of Hal Holbrook playing Deep Throat coming out. And even though people have really started talking about this issue since Watergate, the fact is that the use of confidential sources and confidential information has a very, very long history in this country. And I think it's important to talk just, if only briefly, about the history. The very first known example of an American reporter protecting a confidential source was a man I suspect many of you heard of. His name was John Peter Zenger. He was the publisher of the New York Weekly Journal, a paper that was opposed to the policies of the governor appointed by the British Crown in New York at the time. This is in the 18th century. And Zenger wrote stories quoting confidential sources criticizing the government. And he was accused of violating a statute that was very expansive that said basically you could be prosecuted for criticizing the British government. And he was defended pro bono by none other than Alexander Hamilton. And during the trial, Hamilton told the jurors that if Zenger was protected, it would lay a noble foundation for securing a right to liberty of both exposing and opposing arbitrary powers by speaking and writing truth. Zenger, fortunately, was acquitted. More than 100 years ago, 100 years after that, in 1896, Maryland enacted the very first statute giving reporters a shield from disclosing a source. And this happened after a reporter for the Baltimore Sun was sent to jail for 2 days when he refused to reveal to a grand jury his sources for stories about the bribery of elected officials. And the legislative history of that statute shows that the purpose of the statute was to protect reporters and other newspapers from being compelled to disclose the source of any news or information procured for publication in any legal or legislative proceeding. As Erwin was saying, in recent years, the law has started to evolve since then. In 1970, for the very first time, a federal circuit court gave a protection to a First Amendment protection to a reporter, saying there was a privilege, and this was a guy that I knew named Earl Caldwell from the New York Times, and he refused to disclose his sources and stories that he had written about the Black Panthers. Of course, Caldwell's decision, favorable ruling, was one of 4 overturned by the decision of Brandsburg versus Hayes. The Brandsburg decision, while obviously not a good thing from the point of view of most reporters, because they lost the big issue, even though there was some acknowledgement of qualified privilege, did precipitate a lot of activity in the states to pass shield laws helping reporters. At the time of Brandsburg, there were only 17 shield laws. Now, only Wyoming does not have a law of some form, either in the form of a constitutional amendment, which is what happened in California, or in a statute, or by case law. So there's widespread shield laws all over the country now. The most recent efforts to get a federal shield law passed, as Erwin was referring to, have occurred in the context of both these jailing of Judy Miller in the Libby case and in the BALCO case. And I'd like to talk a little bit about the BALCO case involving the steroids investigation of professional athletes, because I think illustrates both the importance and, to say the least, the complexities of reporters dealing with confidential sources. For those of you that are not familiar, a very quick summary. 2 reporters for the San Francisco Chronicle, a longtime investigative reporter, Lance Williams, and a sports reporter, Mark Fernero-Wada, teamed up to write a whole series of stories about steroids in sports. And it got very splashy when they were leaked testimony from a grand jury investigation of this company called BALCO, which operated this laboratory, that was dispensing these things south of San Francisco. And the first very splashy story was about a sprinter named Tim Montgomery. He'd been a world record holder. And they wrote this story, and shortly, and then got to be a very big deal, and the judge got very exercised because there had been a protective order saying that this material had been disseminated to, defense lawyers and various other people involved in the case on the condition that they not reveal it to the reporters. And both the judge and the prosecutors asked for, an investigation of this. And soon after this story was published, there were, back and forths in court, declarations and so on, and public statements by all the lawyers on both sides of the case saying that they had not been the sources of the leaks, and, the defense lawyers accused the prosecutors of being the sources of the leak. Some months after that, the BALCO, the reporters got another set of grand jury documents and wrote another series of stories, and these were the ones that more focused on the baseball players like Barry Bonds, Gary Sheffield, and Jason Giambi. The investigation amped up after that, and eventually a federal district court judge in San Francisco, Jeffrey Wright, rejected the reporter's claim of a privilege and rejected very specifically a balancing test of the sort that had been suggested of by Justice Powell in his concurring opinion. He simply said there was no privilege and the reporters either had to reveal where they'd gotten the information or they were going to go to jail for up to 18 months for contempt. The reporters appealed, and the case was all teed up for hearing next week in the Ninth Circuit Court of Appeals when, all of a sudden, in mid-February, the government announced that they had found the leaker. And the leaker was a man by the name of Troy Ellerman, who had represented the vice president of BALCO. And Troy Ellerman happened to be one of those people who had said, both in open court and in a declaration, that he had not been the leaker, and he had accused the prosecutors of being the leakers, and he had filed a motion seeking to have the charges against his client dismissed on the grounds that the leak had basically made it impossible for his client to get a fair trial. Now, when...
Chutzpah.
Yes, we could say it put the C back into chutzpah, or the G back into gall. Now, when reporters first heard that their brethren in the press were not going to have to go to jail, people immediately breathed very shortly, and still a sigh of relief that their colleagues weren't going to have to go to jail. But then other questions started to arise, such as, you're a reporter. You have written a story that served a valid public purpose. You have revealed information about the proliferation of performance-enhancing drugs. Your work has been heralded by the President of the United States and parents of kids who became injured by using steroids. On the other hand, shortly after your story was written, your source is attempting to capitalize on your story. What do you do then? There are some people in my profession, including a columnist at my paper, who's a longtime friend of mine, who wrote a column saying it was morally obtuse of those guys not to have immediately outed their source. Now, I think that is a complicated question that I am still wrestling with. I will tell you, there is one passage in our ethics code that we revised a few years ago that you might say could deal with a situation like this. And I want to read you a passage from our code. It says, if a source acting in bad faith were to succeed in using the newspaper to spread misinformation, we would consider our promise of anonymity no longer binding. Now, I want to try and parse that a little bit. If you had discovered that the source had lied to you about the basic underlying information, to me, I guess I would probably feel that that would precipitate, in my own mind, a reason for outing the source, even though I might be putting myself legally at risk under one case called Cohen versus Cowles Communication. On the other hand, in this situation, the initial information that the source provided to the reporters, which was he allowed them to read the transcripts, was not inaccurate. What became problematic was when the source tried to capitalize on his own leak. And I want to tell you one thing, again, this is sort of personally to me as somebody that covers court proceedings all the time, that I think is very dicey about this. Let's say you're the reporter who is covering these court hearings where there's this back and forth about who's the leaker and who's done what, and you're reporting on what's going on in the courtroom or what's in these declarations. Now, you're able to report accurately to a point on what's in those declarations, but I have to say it would be a very uncomfortable feeling for me, and I think for a lot of reporters, to write a story where one of your own colleagues and perhaps even one of your editors who the investigative reporters had shared who the source was, knew that there was something about your story that was incomplete. That's a very tricky situation. And I think a lot of us are going to be trying to work our way through how do we deal with a situation like that. It seems to me, and again I emphasize, I don't speak for the paper, and my thoughts about this are still evolving, but it seems to me that at the point that the source, meaning this defense lawyer, tried to capitalize on his own leak, the newspaper was kind of in an untenable situation from that point forward, because if they simply reported on what went on in court, they would be giving you, the reader, a limited and incomplete view, which some of their colleagues knew was not accurate. And I mean, this is a very difficult situation, and as I say, I am somebody that does not believe, per se, that using leaked grand jury information is per se wrong, just like a lot of times it serves a good purpose to use a leaked CIA report, a report from the Interior Department, or a lot of other things, but it does involve very tricky questions, and I think it's particularly important that we keep in mind a fundamental principle as journalists. Confidential sources should be utilized to advance public knowledge about important sources, not to help a lawyer mislead a judge. Just in closing, I'd like to say one other thing. Although the press is frequently criticized for being overly aggressive, I think the public and the press would be better off if the press was more aggressive in a number of situations where it hadn't been. And just to say one, the nation would have been better served if there had been more penetrating reporting about the claims of the current administration that Saddam Hussein had weapons of mass disruptions. Stories that a number of Washington journalists wrote about that subject were not nearly as skeptical as they should have been, and an editor should have subjected those stories to the same scrutiny that were given to stories about City Hall scandals. When the press does a better job on topics like that, they serve the country better, and in the process, they also advance the cause of why a federal shield law would be a worthy goal. Thank you for listening.
Bussian or Leatherbury? Alphabetical or seniority?
I think home court advantage.
All right. Well, you might judge from this discussion that the press has been twisting in the wind for 30, 40, 50 years while waiting for the U.S. Supreme Court to do something to recognize protection against forced disclosure of any kind from reporters, or waiting for a federal shield law to be enacted. And of course, life's gone on in newsrooms across the country, and with as much visibility as has been given to the recent leak prosecutions, they've been a relatively recent phenomenon, somewhat rare in the lore of most TV operations, and certainly rare in the lore of most daily newspapers, weekly newspapers. The greatest need that these media operations have for protection against disclosure just comes in the run-of-the-mill, everyday reporting assignments on the courts, on civil litigation, subpoenas that come in from plaintiffs' lawyers who want to find out what folks have seen at the scene of some potentially actionable conduct, or at a train wreck, or at the site of a government investigation. Any of the above. We've recently been litigating one in the Eastern District of North Carolina over some church burnings, and the U.S. Attorney, though no charges have been filed, said to one of my clients, "We'd like to see the footage that you aired, most of which had not been released to the public, some of which had been put on websites, some of which even a smaller amount had been put on the nightly newscast, and we want to compare that with what our ATF agents have." Well, that sort of violates one of the sacred rules of news reporting, and that is, if decisions have been made not to publish or broadcast something, then of all the things the government ought to have the least entitlement to see, it would be those things that have been purposely kept off the air, out of the page of the daily press. So we have had to fight subpoenas for at least the 25 years that I've been doing this, mainly to stop incursions of that kind. And, in this circuit, believe it or not, the Fourth Circuit has been way out ahead the federal courts in North Carolina, South Carolina, West Virginia, Maryland, have been the forward guard of recognizing that Brandsburg does afford limited qualified protection to the press in both criminal and civil cases. So we've never had the same ox in the ditch that you're seeing the press trying to drag out in the D.C. courts and in New York and in the cases that we've been talking about here today. And the same is true in a number of other circuits across the country. We've also had good success trying to get state courts to recognize a qualified privilege under Brandsburg, and a lot of them have done so. But as time evolved, not unlike what we've seen in the recent leak cases, state courts began to say, well, maybe it's not what we thought it was. And even where there was case law protecting the press, all of a sudden the roof collapsed. So that, you know, when I was starting out lawyering for the media in Florida 10, 12 years ago, we had to run a shield law, and we got one passed. Then here in 1999, the North Carolina Supreme Court abandoned the press, and I basically had to write a shield law using whatever we had as examples from around the country, and pulled together the best of what we had, and we got it through here in 94 days. We have a definition of media that's probably unparalleled in all the experience of the other states, and it's probably one of the strongest shield laws, you know, protecting reporters in state courts in the country. Our shield law in North Carolina protects confidential and non-confidential information against the well-known three-part test where the government or the party seeking the information can try to show that it's indispensable to their case and that they can't get it any other way. In our experience, a difficult test to meet. And sure enough, you know, Tom can talk more about this, but I've got a number of clients in Texas, and now with Texas being one of the last places that, you know, neither has case law nor a shield law to protect the press, our folks are twisting in the wind there. So we're trying to, and I've just led a contingent to meet with the Speaker of the House in Austin to persuade the Texans. Tom can talk about that because it's been a difficult, long discussion to become the 32nd state, plus D.C., to have shield law, shield protection codified. So I would just offer the only other thought on what Professor Chemerinsky said about the punishment issues out there prior to publication. And I don't know how many people are in here old enough to remember the government's case against Manuel Noriega. Anybody? I was just coming out of law school. A couple people. But anyway, way back when I was just starting to practice law, right, Tom? I think you're the same year I am. But the government tried Manuel Noriega after taking him forcibly out of Panama in the federal courts in South Florida, where I was practicing at the time. And there was an interception of communications between Noriega and his lawyers, and CNN, after having been ordered not to broadcast those things, did so. You know, there's a couple ways you can challenge an unconstitutional order. One of them is to move to vacate it, and sometimes that can happen tomorrow morning, but frequently, am I right, gentlemen, it takes days and weeks. So CNN didn't want to do that. It believed that the order was facially unconstitutional. So the other way you can challenge those orders is to violate it.
Yeah.
Okay?
Risk the
And
consequences.
they did. And at least in my life experience, that's the only time I've ever seen a prior restraint upheld by a federal appeals court. So we know it can happen if the press, you know, has the questionable judgment of violating a direct order, even for a few days, because all that federal judge down there wanted to do, and by the way, he's been a good longtime friend of Duke University and Duke Law School, Bill Hoovler. All he wanted to do is to have a day or two to look at the interceptions and see if it was going to hurt anybody's fair trial rights, and then, you know, have at it. But CNN didn't want to wait, and so here we have at least one real-life example of a contempt citation upheld.
Well, yeah, Texas has no shield law, as John mentioned, and it's very curious to me because it's only within the past 2 years that the publishers and the broadcasters actually agreed that they needed a shield law. The broadcasters, who are used to dealing with the FCC and other governmental officials, were much further ahead of the publishers in saying, we just need to go to the legislature and get a shield law. The publishers resisted and resisted and resisted and resisted because, you know, what the legislature gives, it can take away, and they didn't trust how it would come out in the process and those sorts of things. The district attorneys and county attorneys are staunch opponents of the shield law in Texas for no good reason, I think, but they are, and I don't think it's going to go anywhere this session. But so essentially what you have in where I practice is, if non-confidential information is involved, if it's just outtakes, if it's just the footage you shot of the car wreck after it happened, or the rest of the interview that you had in the jailhouse with the defendant, with whom you had no confidentiality agreement, then they are not even fighting those subpoenas now. They are letting the prosecutors or the people come in to see the film, and if they want it, they're giving them a copy of it. Or many clients are. Some clients are still resisting. If there's a confidential source involved, then yes, they will fight those and at least delay the inevitable and maybe get lucky. And so they do fight those. It's almost as if the times when you have a client who will resist a subpoena, it reminds me of a situation I handled when I was a really young lawyer, because you get the call from the courthouse, the client says, I've been subpoenaed, they want me, I wrote an article and it quoted a source close to the court, there was a gag order in place, yeah, I probably violated the gag order, yeah, the source probably violated the gag order, but you got to come down and help me. And so you crank the 3-page motion you have in the can on your word processor out, and you're studying, and you got your latest PLI communications law volume, and you're frantically going down the courthouse. And this reporter was really calm. I mean, just incredibly calm. And I said, okay, you don't have to tell me who the source is. I don't really want to know. He goes, oh, that's okay. I feel really good about this. The judge was the source. And so maybe when the outcome is quasi-guaranteed, you would fight it.
Great story.
And so
Yes, great story.
the whole hearing, the judge kind of sat there going, Anyway, you still fight those, but you don't fight many more. On the national security issue, I think most of those stories are originating East Coast or West Coast, and we don't have a whole lot of national security stories that originate with my clients in Texas. But I can certainly identify, because I've represented several reporters, as John has, I'm sure, who've been threatened with criminal prosecution for various alleged law violations. Everybody from a Dallas Morning News reporter who was accused of stealing and or receiving attorney-client communications in the Oklahoma City bombing case and then publishing those, to a TV reporter who was given illegally made audio tapes that revealed widespread corruption in a local school district, and then used those and published those, and was threatened with criminal prosecution under the Wiretap Act for receiving and using that information. And my experience with that is sort of colored, because I really think the groundwork for the aggressive government posture towards the press was really laid in those wiretapping cases by the Clinton Justice Department. They took, in my opinion, extremely conservative anti-First Amendment positions in all those wiretapping cases. And it was sort of a systematic ignorance of the impact that the wiretapping laws had on the press's ability to do their job and to deal with sources and receive information from sources. It was the premise was sort of the equation of stolen information with stolen DVRs from an appliance store. You know, and so if stolen information that has that's relevant to a public controversy, the receipt of that could be criminalized, just like the receipt of stolen property from an appliance store robbery or stolen desk chairs from a government office could be criminalized. And it was, to me, left much to be desired in terms of analysis. It also left a huge gray area between, or a gray area in the area where reporters deal with sources. There's just a whole lot of gray between something that probably should be criminalized, which would be bribing, coercing, threatening, that sort of thing, and on the other end of the spectrum, passive receipt of information from somebody. You know, it comes in over the transom, like the radio tape in Bartnicki. You don't know where it came from, but it comes to your attention and it's publicly important information. There's a lot of gray in there of conversations between reporters and sources that could arise to solicitation, could rise to aiding and abetting violations of these statutes that Erwin talked about. So I have a little bit of a historical view on this. I think it started back then, and I think we've seen that trend continue. I guess one place where I'm really interested in both the security cases or the Espionage Act cases and the Reporter Shield cases is what one of my clients calls wedge issues. And these are issues that drive wedges between reporters and their sources, issues that drive wedges between reporters and their editors, and reporters and the corporate publishers. Incredible opportunity for conflicts of interest in this area when you're threatening to put somebody in jail or to impose sanctions of $25,000 a day for failure to reveal confidential sources. I mean, these are issues such as who has the authority to grant a promise of confidentiality? Is it the reporter in the field? Is it an editor? Can an editor overrule a reporter who's already granted confidentiality? Who owns the emails on the computer that you have sent to your source? Who can turn those over to a prosecutor or defense lawyer or grand jury, like the dispute between Matthew Cooper and Time in the companion case to Judith Miller? Who owns the phones? They say that the reporters have to Mirandize their sources, that I may have to give you up. I'm not going to jail for you, so speak now. You have the right to remain silent. These are all very important issues that impact the day-to-day journalism and the quality of the news that we get about government operations.
Well, let me ask, what do you think the chances are of getting a federal shield law passed, maybe with the new Congress? Any?
Slim.
Mm-hmm. Slim and none.
So then I would just add to that all's not lost. A fellow who used to be the general counsel for Dow Jones is now a Second Circuit judge, a guy named Bob Sack. In fact, he's written a well-known treatise on media law. And he wrote a dissenting opinion just this last August in
Gonzalez.
United States versus Gonzalez, where the court essentially found a federal common law reporter's privilege, but then proceeded to say that the government had overcome it. Sack boldly wrote a 38-page dissent and said, no way did the government overcome it. So I still say, even without it, even in those courts that refuse to recognize it, we've still got a chance to fight another day.
And I want to add there, one of the new developments with regard to trying to get shield protection for reporters in federal court is a claim of a common law privilege that reporters have. And this was presented in the BALCO case in the briefs to the Ninth Circuit. Obviously, as Henry says, a case that's never going to be decided there. If you've taken evidence law, you probably read Jaffe versus Redmond. You might have even read it in civil procedure, where the Supreme Court recognized a therapist privilege even though it's not within the federal rules of evidence, as privileges aren't in the federal rules of evidence. Well, what was argued in the BALCO litigation and was argued in the Second Circuit case that you mentioned is, apart from the First Amendment, there should be recognized to be a common law privilege for reporters to keep their sources confidential in federal court. And that's really in its early stages of development in the federal courts.
Why don't we open it up to questions if people have questions?
I'm a little confused. You said you have church burning footage, then you have the sacred duty not to turn it over to prosecutors. What is the sacred duty that prevents you from helping prosecutors punish church burners?
Well, it's not so much a duty not to help prosecutors as it is a First Amendment right not to be forced by the government to disclose things that haven't been aired to the public generally. So in the editorial process, there's a decision made every day on every story, how much footage is going to be shown to the world and how much footage is going to be kept as outtakes and in a file that nobody ever sees. That process by which people decide how much of an interview you're going to read and how much of a crime scene you're going to see is what's protected by the First Amendment. So it's not so much that any of these clients, mine or Tom's or anybody else, want to hide things from prosecutors. It's that they don't want to be forced by the government to reveal things, especially things that haven't been aired to the world.
Well, and the practical thing I would say is, and I say this to prosecutors sometimes, I mean, do you think we kept back the really good stuff? I mean, do you think we didn't broadcast the really good stuff? I mean, that's what frustrates me about this, because many times prosecutors subpoena things when they know there's nothing there. They're not even going to read it or look at it, as happened to us over in an East Texas case one time where a reporter went to jail twice for not disclosing the outtakes of an interview of a criminal defendant. So it becomes a lot about ego, I think, about the prosecutor. You know, I'm the prosecutor, damn it. You're going to give me your stuff because I'm entitled to everyone's evidence.
And one more thing on that note. As we've said to all of them, you know, the Justice Department has guidelines that they're supposed to run through before they come to you if you're a news director at a TV station, and satisfy themselves and then get approval from the U.S. Attorney General that they've looked all through the witnesses they have and all the evidence they've acquired and satisfied themselves that really they can't get what you have any other way. A lot of times they haven't even attempted that analysis, and in this case that we're talking about, they had ATF agents all over the place, and they have footage that they collected and witnesses that they interviewed, and we just simply say, look, if you think you can overcome our privilege, you know, tell us how. Tell us why you don't have the reasonable equivalent of that right now. Is that another way, Tom, that you've gone at it?
Yeah. Oh, yeah, absolutely.
Right.
Yeah, the Department of Justice, the guidelines are observed more in the breach than in the observance, or whatever, however that saying goes. In fact, this case over in East Texas, it was really it was a state prosecution, but the feds were running it because it was a hate crime. And they took the position that even though the feds were involved, they didn't have to satisfy the Justice Department guidelines before they issued a subpoena for this producer's footage.
So it's not just an intellectual curiosity.
Can I ask a follow-up really quickly? It seems like there's a really strong reason for preventing the disclosure of confidential sources, that if you disclose those, and there's a likelihood you will, there'll be less of them in the future. But there's not going to be less video footage of crime scenes if they're often turned over. It's not as if I see a church go up in flames and I take out my my video camera and my cell phone, I'm going to stop doing that because there's a chance I might have to show the police that later. So I just don't understand any rationale when it comes to video footage.
I'm not your investigator. That's the rationale. Mr. Prosecutor, I am not your investigator. You have your investigators.
But if I happen to have it on my cell phone, I should have to turn it over if they're investigating the crime.
They're not eyewitnesses in this situation.
They're not.
They're not eyewitnesses. They didn't observe the crime. They got there maybe after the ATF agents did.
And they said what they were really looking for is they want a scan of faces in the crowd. Well, you know, they've already interviewed the crowd and taken pictures of everybody on the scene and filmed who was there after they got there. And so we just asked them to to satisfy the guidelines.
I just want to insert here a little bit about the law as his background, taking no position as that. There was a case involving the Stanford Daily where the police literally went in and searched the newsroom of the Stanford Daily to get the outtakes and the information that they wanted and the pictures that weren't published in the newspaper. And Congress then adopted a specific statute limiting the ability to search newsrooms where what was going to be gathered was the fruits of their investigation. And so one statute that we haven't talked about here that would apply directly to your question is the statute that was adopted in response to the Stanford Daily case. The other thing is there's been one Supreme Court case about outtakes. There's a lot of lower court cases. And that was in a defamation context, a case called Herbert versus Lando, where it was a suit against 60 Minutes. And it was, if you've taken First Amendment, if you're dealing with a plaintiff who's a public official or public figure, they can recover for defamation only if they prove with clear and convincing evidence that the statement was false and uttered with actual malice, that the speaker knew it was false or acted with reckless disregard of the truth. So knowing the subjective intent of the reporter becomes very important, and so the outtakes can be crucial for this. And here, 60 Minutes producer claimed that the outtakes are protected by the First Amendment, and the Supreme Court flat out rejected that protection. Now, some lower courts are much more protective of outtakes in the non-defamation context, but that's the one Supreme Court case that's relevant on point there.
Sonia?
I have a question about the Espionage Act, and we've talked about, you talked about how it's unclear about the mental state that's required, and it's never been tested, I guess, on the press. I wonder how the 1941 case of Gorin, the United States, and the bad faith requirement.
Gorin, of course, is about 793A and 793B. Gorin does not involve the provisions that I was talking about, C, E, or G. And so that would be the distinction. And as to the provisions that I was talking about, they have never been used against the press. And so the mental state that's required is unclear. If you haven't done so, I really recommend reading the United States versus Rosen District Court opinion from last August, because there's a lot of discussion there about what's the Siena requirement. The press is trying to argue that Gorin should be applied and that there should be the same intent requirement for C and E and G, which is what's at stake in the Rosen case. But the United States government is saying no, that Gorin is just about A and B and doesn't involve these provisions.
Yes, please.
Given the new provisions for the Espionage Act, nobody really talked about this. I'm just curious if it would protect people such as, I think it was Geraldo, right, who is embedded with a unit in Iraq and very apparently clearly disclosed the location of some of our troops. I'm curious if this would sort of insulate those types of prosecutions, or, and if, I guess if you could just comment about that.
Yes, talk about Geraldo Cienter.
I think it's a really interesting question because, the Espionage Act is, the provisions I was reading, seem so oriented towards prohibiting people from disclosing classified information, publishing that, being an unauthorized possession of it. What was going on with Geraldo, as I understand it, was he was with troops in Iraq. There were regulations that limited where he could go, and he violated those regulations. I don't know that the Espionage Act would apply in that circumstance. And I think what the government did was say, you lose your ability to be there, and he was pulled back.
Yeah, I think that that's right, and it's sort of a noteworthy exception to one general principle, which is that in general, a governmental entity, at least there's case law on this, unless it's been eviscerated, can't prevent a reporter that they dislike from going somewhere. Like if you're going to have a press conference, you can't say, well, Weinstein, I don't like the way you've written about the cops, you can't come in. There's a couple of really good decisions on that, but obviously those are different than, in a combat situation like this where there was a disclosure that I don't think anybody would have endorsed except for maybe Geraldo. Pardon me, I'm not a fan.
The good decisions, except in Maryland.
He's been extraordinarily kind to me.
I'm sorry, man. I'm sorry.
I want to get your opinion if you think there's enough institutional restraint to justify having the shield laws, and especially, I guess I'm looking at it from the perspective of the BALCO case and the leaked grand jury testimony from Giambi and Barry Bonds and that sort of thing, where there's this huge carrot out there. I mean, if you can get, especially a guy like Barry Bonds saying, I had the cream and the clear and all that stuff, I mean, you're gonna get, makes a real name for yourself. Is there enough institutional restraint to justify having like a shield law that would protect that? Because I think there's a real public interest in having protected grand jury testimony. And is there any kind of restraint in there that reporters are saying, no, we're not gonna publish this for that public interest?
Well, I mean, if you look at, let me try and not hit the question directly, but talk at some of the factors. I mean, when those stories came out, people had already been indicted. The and the five people have been charged. They pleaded guilty. Of course, Bonds' trainer himself went to jail for some period of time for refusing to disclose certain things. None of the athletes themselves have been indicted. Bonds, as you know, is still the subject of another ongoing perjury investigation. I don't know that it's going to come to anything, but certainly that case, at least as far as I know or I have read, was not compromised in any basic way. They got their convictions. I think that there's also pretty general agreement, although there. In most quarters, although the prosecutors did disagree with some of their briefs, that those stories did serve a very salutary public purpose about raising public consciousness about the dangers of performance-enhancing drugs. I don't think there was any question but that it forced Major League Baseball to take action that it hadn't taken up to then. It spurred congressional hearings. I understand that there clearly is in certain forms of stories that it can be your ticket to becoming a bigger name in your field or something like that. I really think that most people are pretty prudent about how they approach this stuff. I will tell you, I've written about a lot of federal criminal cases, and it's and there aren't a lot of cases. I mean, there are some, obviously, but there aren't a lot of cases where there is leaked grand jury testimony. I've only once had the experience of talking to people before a case was charged, of talking to somebody who had testified in a grand jury, and that's in a case that's ongoing in Los Angeles involving sort of a lot of illegal wiretapping in the entertainment industry involving a famous private eye named Anthony Pellicano. And at one point, a bunch of several witnesses who'd gone in front of the grand jury, who thought that their calls in civil litigation had been tapped and that their cases had been compromised because they'd been spied on, they got disgruntled, and they actually talked to us about their testimony because they thought that nothing would ever happen in their cases. They just thought that nothing would ever come of it. And they finally got so fed up, they started, for me, I thought it was an out-of-body experience. I couldn't actually believe that somebody who'd been in a federal grand jury room was talking to me about it. And in that instance, the government made no attempt to take any action against it, because partly I think there was nothing about a confidential. We quoted the people that said, and they said what they said, that they thought they'd been, tapped and so on and so forth. But I understand your concern, but I think most people are pretty restrained about this stuff.
Great. I think we have to finish up, but please thank the panel for coming today.